Hey guys, welcome to this video. This is John Watts, and I want to go over this Fair Credit Reporting Act case. Now, normally when we think of the Fair Credit Reporting Act, we think of our normal type credit reports, Equifax, Experian, TransUnion. This is actually a little bit different. This is when an employer says, I'm going to pull your credit report or do a background check on you. And the law is very specific when anybody wants to pull or access our credit reports. And then it, in particular, has very specific rules on employers doing that or potential employers doing that. So this is out of the Ninth Circuit from the beginning of this year. It's the Gilberg case. So pretty simple facts, actually, and the court, this is not a real long opinion, but I think you'll find their analysis interesting. And so we start off. Widespread use credit reports, background checks led Congress passing the FCRA. So specifically with employers, we have some rules. To obtain a consumer report on job applicant, you must give the applicant clear and you have to meet both of those, clear and conspicuous disclosure. And then in a document that consists solely of the disclosure before you actually get the report. And so two questions this court faces. Number one, that standalone requirement, is that met if there's extra information on the form listing various different state requirements? In other words, if you're in New York or if you're in Nevada or if you're in this state, does that take away from that standalone? And then number two, whether this particular document was clear and conspicuous. And so the court refers back to a 2017 case, and it says that the clear statutory language that the disclosure document must consist solely of the disclosure. And so they say, consistent with that, we rule the same way. So we now hold a prospective employer violates FCRA's standalone document requirement by including extraneous information relating to various state disclosure requirements. And then they say, we find that the disclosure here is conspicuous, although they're a little critical of it, that font size or type size, but they find that it is not clear. So here's the background. This person, Desiree, was looking to work for CheckSmart Financial, and they gave her a 3-page form that's employment application, screening, stuff like that. And then there's a separate form entitled Disclosure Regarding Background Investigation. And that's what this lawsuit is about. And they notice in here, what type of font, the size of it. And like I said, they're critical about it. But here's the background disclosure notice. And it's talking about we may obtain information from a consumer reporting agency, and then it goes through and lists all the stuff that may be involved there. And then this is where it gets interesting. They say, all right, if you are in New York and Maine, here's some additional information. Okay, here's New York, here's Oregon, here's Washington. And then it's got for them to sign California applicants, employees only. Here's Minnesota and Oklahoma. Here's New York. And so they do some research on her, give her a job. She ends up leaving and brings this class action with two claims here. One is the FCRA, Fair Credit Reporting Act. And then there's basically the identical version of this law is a state law under California law. And we're really just going to focus on the FCRA, not to spoil it, but the California law just tracks that in this opinion. So here we go. The FCRA prohibits an employer from obtaining the consumer report without first providing with a standalone, and that's critical, standalone, and then clear and conspicuous disclosure of its intention to do so. In other words, you can't trick the person or be confusing or put in super tiny type size, and then the person signs and they don't realize that they gave you, the employer, the right to pull their credit report. And so now this is going to the law 15 USC 1681, and you can see it goes on into various subsections. So you may not procure or obtain a credit report for employment unless, and then we have clear and conspicuous disclosure is made in writing to the consumer before the report is pulled. So in other words, you can't pull the report and then go, oh, we pulled the report. Let's get them to sign clear and conspicuous disclosure. And then the law also tells us it must consist solely of the disclosure. And then we have consumers authorized in writing the procurement or obtaining of that report. And then California has its own, which again, we'll skip over that. So CheckSmart moves for summary judgment. That's saying there's no reason to have a trial on this because no reasonable juror could rule against us. And the district court agreed with CheckSmart, entered summary judgment against the plaintiff, and said, hey, that disclosure form complies with Fair Credit Reporting Act. So then the consumer appeals. And so now let's look at the relevant disclosure form. And the employee makes sort of an odd argument. They say, well, you got to look at every form I filled out. That's a total of 4 pages. And she makes the argument, well, document in a contract sense means all the things that relate to that. And the court goes, no. The only thing that's issue here is 1-page disclosure. So they say 3-page employment packet, in other words, like your application, there's some test on it. That has nothing to do with your disclosure. We're just looking at the 1-page disclosure. So they say the disclosure form alone. That's what we're looking at. And then they say it violates the standalone, which is her argument. They say, we agree. And they say, remember, back in 2017, we looked at this in the Syed case. And so in this one, let me highlight this. Prospective employer violates the section when it gets the consumer report after including a liability waiver in the same document. And then they say, and if you've seen our other videos, you'll notice this is pretty common for courts to say this. We conclude the statute meant what it said. The required disclosure must be in a document that consists solely of the disclosure. And they say it's a plain language, noting where congressional intent has been expressed in reasonably plain terms, the language must ordinarily be regarded as conclusive. And then they say other provisions omit the term solely, so obviously Congress knew what it meant when it put it in this particular section. And CheckSmart says, no, that case doesn't have anything to do with ours because there was a liability waiver. And that was taking away rights of the consumer. And then they say, if you look at ours, it actually gives you more information and it enhances the protections under the FCRA rather than takes away. They say, we disagree. So that previous case was not limited to liability waivers, and we were talking about any just extra information. And they said, look back at our 2017 case. We looked at the word solely means, and there are no implied exceptions. And they said, we even told people, don't be thinking that you can get all these additional implied exceptions like the statute says solely, but you go, but that's okay for me to add X or Y or Z. And they say, we're not going to create an implied exception here. And this is an interesting argument they make. They say, look, talking about whether it's useful to tell you about more rights, they say that does not override the plain meaning. Congressional intent, reasonably plain terms, regarded as conclusive. Let's look at the word solely. What does it mean? Alone, singly, entirely, exclusively. And they say, since your disclosure form, remember that 1-page document, does not consist solely of the FCRA disclosure, it does not satisfy the standalone. And then they say, even though they don't have to, they say, look, it really doesn't enhance or fit with the purpose because it's talking about rights of states that don't apply to her. And so, it's kind of like this. Imagine this document had disclosures for all 50 states. But they know what state you live in. They know what state you're applying in. So why put all that other stuff? Well, their response would be, well, it's just easier. We don't want to make, 50 different versions of this. We just want one document we give to everybody. Well, that becomes overwhelming. And the court even says in here, because that extra information is as likely to confuse as it is to inform, it does not actually further FCRA's purpose. And the court, or the Checksmart, cited a 2016 case, trial court, district court, and the Ninth Circuit said, well, no, our decision 2017 sort of undercut that, so you shouldn't be relying on that. And so here's the summation of it. Is standalone requirement does not have any implicit exceptions. Your disclosure contains extra irrelevant information, and therefore it violates the law. And even if we looked at the congressional purpose, much of the extra information does not enhance the purpose of the FCRA. So therefore, the trial court erred in concluding that it's satisfied. And then the same would be true of this state law. And then they talk about clear and conspicuous. So that's the test, clear and conspicuous. But these words aren't defined in the statute. So for example, in the FDCPA, we have section or subsection A, so it would be 1692A gives us a list of definitions. Here we don't have that. So they look at other laws to see, well, what does clear and conspicuous mean? So here we have reasonably understandable. We have clear means language used in disclosure must be cast in a reasonably understandable form. Conspicuous means readily noticeable to the consumer. And they say, while that's one single statutory obligation, we analyze each prong separately. And they say, all right, first of all, is this clear? Well, look at this. This is the disclosure. The scope of this notice and authorization is all-encompassing. Well, what does that mean? However, allowing Checksmart to obtain from any outside organization all manner of consumer reports and investigative consumer reports now, and if you are hired throughout the course of your employment extent permitted by law. What in the world does that mean? I mean, however sounds like it's going to limit it, right? It's all-encompassing, however. But the sentence doesn't even make sense. And so the court points this out. Beginning of this sentence does not explain how the authorization is all-encompassing and how that would affect the rights. The second half, followed by a semicolon, lacks a subject and is incomplete. It suggests there may be some limits, but it doesn't identify what those are. And then second, it would confuse a reasonable reader because it combines federal and state disclosures. So it's got New York and Maine, and it says reasonable reader might think only New York and Maine applicants could contact the Consumer Reporting Agency. That would be wrong. So they say it's not clear, but they do say it's conspicuous. And that just means readily noticeable to the consumer. And so they applauded Checksmart for capitalizing, bolding, underlining. They got headings. It's labeled. Although the font is small and cramped, we think inadvisably so. It is legible. And all the information's on the front of the page, the headings. So they say, you know what, it is conspicuous, but Checksmart, for you to win it must be clear and conspicuous. And since it was not clear, the conspicuous doesn't matter. So again, the court erred in granting summary judgment. So they send it back to the court to say, move forward with this case. And that's the opinion that I wanted to cover today. So if you have dealt with an employment background check where you went to an employer, whether they hired you or did not hire you, and they gave you a disclosure form, check out that form. Now, understand different courts can interpret this differently. This is mainly the West Coast, and we'll look at some other cases that involve similar things. But just start looking at it and say, okay, Was it a standalone document, or did it have all this extra stuff in it? Was it clear? Was it conspicuous? In other words, was it noticeable? And then from a clear standpoint, did it make sense? Or was it just a bunch of gobbledygook? What was it? And if you have a question about it, feel free to get in touch with us, alabamaconsumer.com. You can contact us through there. Be glad to help you think through it. When they get this wrong, it's not just against you. It's going to be against a bunch of people that they do it wrong. So typically these are handled in a class action type setting. And I think if we go back up here, yeah, so this was filed on behalf of herself and all others similarly situated. So that's a class action. And it's a way to get companies to change what they're doing so that they will start following the law. So thanks for watching this video, and I'll catch you guys in the next one. Bye-bye.